все девочки, которые волонтеры, они все знают, все.
Okay, colleagues, I think that we should start. As I mentioned, let me first introduce myself. I'm Glenn Bellini. I'm a partner in the Moscow office of Dentons, and I have worked on this panel on pro bono last year before I introduced the idea of pro bono and legal aid panel this year. In discussions with the Ministry of Justice, they asked how we began and for us to assist in organizing it. But they promised that we would have as a moderator Minister Konovalov. And on Monday we found out that he wouldn't be able to join us, and we were promised his deputy, Elena Borisenko. And we're very much hoping that Elena will show up. She's promised to do that. But whereas we thought to begin the session today with Elena, we will put her in at some point when she comes. So our next thought was that we would start with Edwin Rekash from PIL in the US in New York. That this presentation was not received or was not uploaded properly. And so they're trying to address that problem now. So there'll be a little bit of changes in the way that we had imagined structuring the program. We'll have to sort of be flexible and play it by ear. So at any rate, though, I think we should start because it is Friday afternoon. And first of all, I'd like to start by welcoming you all here, and particularly in light of the fact that this is the last session of a very rigorous two-day program, which I understand ran until at least 5 a.m. this morning at Shapur, with the Lulz party. Many people may still be recovering from that. And this being the last session for the evening activities, it's particularly good that we have a lot of people here, hopefully more will attend. As you know, this is the most important session of the forum. Because all of the other sessions are about various theoretical matters that are of great importance in various professional matters, but this is really about the lawyer's obligation to assure that justice prevails in society, to assure that all citizens of the society, poor or rich, have access to legal services. And so, in many ways, I think this is the most important of the activities of the forum. And I hope that one of the things we can take away from this is how to. Okay, so maybe we will start with you then. It's how to promote pro bono and how to assure that all people in Russia and in all countries have access to adequate legal services to protect their constitutional rights. Today's session is, let me say that last year we focused a little bit on why it is important to perform pro bono, how pro bono legal services should be performed, how to motivate people to perform pro bono, why pro bono is important in law firms. And this time, that will also, of course, be very relevant, but this time we want to in particular put an accent on the issues of to what extent is the government responsible for assuring, for instance, financial support for legal services for the poor, and to what extent is this a social responsibility, a responsibility in the first instance of all of us as professionals, as lawyers. So this is an issue which there's no one correct answer to, and there are various approaches that are taken by a number of countries that have wrestled with this issue to one extent or another. In Russia, the law on subsidized legal services is a rather new one, and the implementation has not always been a smooth one. Okay, so I think what we'll do is we'll go back to plan 2, rather than switching to plan 2, which we can't implement at the moment for technical reasons. But let me introduce Elena Adolfo-Borisенko, who's since June of 2012, if I'm not mistaken, is Deputy Minister of Justice. And Elena, believe it or not, has many other responsibilities than organizing this wonderful forum, although you could imagine that this could be a full-time occupation for many less talented people like Elena. But in addition to the many other responsibilities, Elena is responsible for legal aid and the implementation of the legal aid law that was adopted in Russia, and will be able to tell us in particular what plans the Ministry of Justice has for the development of legal aid and the assurance that all people in Russia, poor people, have good access to competent legal services. So, Elena, if you could start.
Thank you very much, Glenn. I'm sorry for being a bit late for the beginning of the discussion. First of all, I'd like to thank Glenn, you and all the members of this panel for the agreement to participate in this panel. I hope we shall have an interesting discussion. The topic is really important, necessary, and interesting. In Russia, the Ministry of Justice is the body that provides coordination of all the stakeholders of the system, providing pro bono legal services. The system is subdivided into two main blocks. First is regulated aid, which is subsidized and financed from the budget of the Russian Federation or from the budget of the entities of Russian Federation, and it is subdivided into two parts. One part is obligatory protection on criminal cases, which is done by advocacy according to certain rules and is financed from the budget. I will speak about this issue in detail. The second part is free legal aid for citizens, also subsidized from the budget, on civil cases of certain kind. These are cases of children, orphans, disabled persons, war veterans, and a number of other kinds of citizens that do not have enough money for litigations. So this activity is also financed from the budget. In the year 2012, in Russian Federation, there was adopted a law on free legal assistance, which has determined these institutions and determine the notions as well. And the main point is that the system of non-governmental legal aid was institutionalized as well. It is not financed from the budget, but is nevertheless subsidized. It is subsidized by the stakeholders, participants of the market of legal services, by associations, by bars, and an important role in the system is played by legal clinics of legal schools. Thus, the system of subsidized assistance in Russia consists of two parts, the state and non-state, private, which is provided by barristers only. Let me tell you what concerns the Ministry of Justice and what we're planning to coordinate in the near future. The first issue is the assistance provided from the budget to the lawyers. There are several problems. The first problem, which lawyers always mention, these are low rates, low payment for such work. I do agree that at the moment in Russia the rates for the services provided are low. But at the same time, in the advocacy, there is no effective mechanism of control of quality of provided legal assistance. This is the problem that we're trying to solve together with the Federal Bar Association, since at the moment advocacy is not ready to be the coordinating body who will determine who to send to do this work, to solve a certain case to certain clients. It's a kind of chaotic structure. Nobody controls the quality of this work. While we're working at solving of this issue, we have had a successful 5-year experience of legal government bureaus. Though that was only dealing with the civil cases, I believe the experience was still very interesting, since, let me tell you what it was about. In 10 entities of Russia, there were formed the government legal bureaus with small staff. Their functions were providing legal assistance to poor people on civil cases and a legal consultation on these cases. The people who applied received consultation from the people of the staff of that state legal bureau, and if they needed protection at court, there were two options. If the staff had an expert, they would get it from the staff, or an agreement with a barrister was made. The difference in case of the agreement with the barrister right away is that there was a professional client in that chain, since a client applying for legal assistance does not always adequately set the tasks or assess the results of work. Thus, the practice of work of these legal bureaus seemed very interesting to us. Unfortunately, we didn't have an opportunity to disseminate this experience all across the country, but we do use this experience for suggestions within the advocacy. I believe it would be great if within the advocacy there would have appeared such a center of coordination that could solve the problems and the issues of quality of legal aid provided to citizens. We need to do this part of work together, and we'll be happy to have some experience exchange in this field. I know there's a certain interesting American and European experience that exists, and we definitely have fields for cooperation. The second direction is the development of motivation for pro bono assistance. We believe there are several other entities besides legal companies that have for motivation, training of personnel, providing of certain experience for them and making them socially important. There are other stakeholders like bar associations, NGOs, political parties that also have the motivation for high-quality organization of centers of free legal aid. For us, it's important to determine the standards of providing such legal assistance, and in the Ministry of Justice, we are now developing the standards of providing free legal aid subsidized by the budget and not by the budget. The standard is necessary. At present, in the Ministry of Justice, we have a list of non-state centers of free legal aid, and its rules were just adopted. Only one center has been registered, but we believe that soon we'll have a serious list of non-state centers, so we'll have a map of centers of pro bono legal aid, institutionalized or not, that do accept or do not accept. I will refer to it separately, the standards, because the acceptance of these standards shall be voluntarily. We believe this work is of vital importance. Its importance is supported by the fact that the government of Russia decided to make the government committee on providing of free legal aid. It's headed by the Minister of Justice, Mr. Konovalov, and we hope that this coordination shall enable us to form an efficient network of state and non-state centers of free aid, and they will vary depending on the features of different parts of Russia, and they'll provide legal aid for poor people. Let me note the following. I understand that I'm short of time. First of all, we invite everybody for the discussion, for the dialogue, and we're interested to get assistance in the development of suggestions, methodology, materials, resolutions. This work is of vital importance for us. The second thing that I'd like to note, a while ago with the colleagues from Pilnet, we have discussed that the word free is a wrong word, because it's never really free. It's always subsidized in a certain way. If it's not subsidized by the state, it's subsidized by the time invested by the lawyer, by the law firms. Somebody does spend money, and a lot of money, for the providing of this assistance. So we would love to have a certain project. We're ready to discuss such a project. Maybe premiums or prizes that we could give to at the forum to the companies and NGOs that help to create a good system of free legal aid. It would be good to motivate business as well, and to improve the image of the profession of a lawyer, so that the society treats us not like it was quoted by the colleagues at the plenary meeting, Chekhov, those bloodsuckers, doctors and lawyers. That's what Chekhov mentioned. We want to have different attitude to our profession in the society. We want the society to be friendly towards us. So I believe that these projects are important for us. That's it. Glenn, I was brief, and I'll be happy to answer questions, if any.
to the legal aid side. Oops. Okay, so I think that gives us a good introduction to the legal aid side of the question, and to sort of flowing from Yelena's presentation, I wanted to give you a quote that my assistant found today that I think is very short, but sort of follows on nicely to Yelena's idea, for instance, of awards and how important it is to motivate people to perform pro bono services. One of the well-known figures in the area of pro bono legal services, and who, as I mentioned in the forum last year, had the rather audacious idea of requiring pro bono services as a requirement for law students in order to graduate and become lawyers in the state of New York, Judge Lippman. And on Tuesday, he was hoping to come to the forum, but unfortunately was unable to, and has promised to come next year. And on Tuesday, in the United States, they celebrate Law Day. Actually, I didn't know this. I only found that today. I must say it's embarrassing, but we celebrate Law Day, which is to promote the rule of law around the world. And at a celebration of Law Day, Judge Lippman said, "The legal profession should not be seen as argumentative, narrow, or avaricious, but rather one that is defined by the pursuit of justice and the desire to assist our fellow man." And I think Yelena is absolutely right that it's extremely important that the image of the legal profession that people throughout Russia and in all societies have is of an institution which is designed to promote justice and to assure that all people have legal services, and not just a business designed to maximize profits. We have, at least many of us feel, an obligation to society, not just to promote our businesses, but to assure that justice is uniform and equal. And indeed, without that, really, justice can't exist at all. At any rate, I think that maybe if there are any questions at this point, we should have a few questions, either from the panel or from the hall, with respect to Yelena's presentation. Could we have a microphone? And представьтесь, пожалуйста.
Please introduce yourself. The Bar Association of the City of Moscow, Mr. Shkret, Valery Shkret. I'm the barrister. I have a kind of clarification and a question. The explanation is as follows. I do not contradict. Yes, the goodwill and honesty of the barrister and of any legal service should be controlled, and certain standards shall promote that, shall be a good tool for that control. But professional risk of a lawyer's business is also very high. When a lawyer gets the task to conduct a case, he gets the information from his client or from the third parties, whatever. And he forms a certain legal position, but when, during the litigation, he gets to know the other circumstances of the case that may change the structure of the whole case and his legal position as well. Client does not always understand this fact. I would say he doesn't want to understand it. And thus the obligations accepted by the barrister when he accepted the task cannot be carried out due to objective reasons, due to the actual reasons that do not depend on him. Hence, I wouldn't be so stringent about the control of the professional activity of barristers, since the very profession of a lawyer at providing of legal assistance testifies to the fact that this framework cannot be set precisely. If you want to oblige a lawyer to always have success, to provide 100% to have 100% success, you may kill advocacy, because no lawyer may promise you 100% success. Wait a sec, I will ask a question as well. Here is my question to you. So what principles of standards shall be used, considering the fact that the professional risk is rather high? So what does the Ministry of Justice think about it? Of course, the principles shall never include the guarantee of success. We're all professionals here, and we understand. I used to be a barrister myself, so I understand quite well what you talk about. When we talk about standards, I talk about such horrible cases that still exist. We sometimes find out that a certain barrister had 30 or 50 hearings at court, or he represented 30 or 50 clients at the same time, on the same day, and received compensation from the state for each of that, which is impossible. That means he didn't provide any aid. He just signed the documents. I'm talking about a standard that would provide ethical norms, including a banning of the conflict of interest for the barrister. I'm talking about normal, ethical, clear principles of providing of legal aid that will provide honesty at providing of legal aid. I'm not talking about legal positions that are chosen by the lawyers in certain cases, but nowadays, unfortunately, and that's to accuse mainly professional corporations and not the Ministry of Justice. Our professional corporation hasn't yet developed clear professional principles and doesn't introduce discipline sufficiently. I wouldn't say it's bad everywhere. The advocacy of Moscow is okay, thanks to the work of Mr. Reznik, the president of the Bar Association of Moscow. But in general, in Moscow, discipline is rather low. We have plenty of materials about it, plenty of information. I will not tell you everything that we plan regarding the standards. We have a working group doing that, and we invite you to participate in this work.
Standards applies not just to pro bono work, but to all legal work. So it goes somewhat beyond the bounds of our discussion today. It's indeed a very important question, how even a client who pays for legal services can be assured that they get a quality service, and whether that needs to be enforced through some sort of a mechanism or a self-regulating organization like a bar association. But I think that goes a little bit beyond the scope of today's issue. We have another question over here. Someone could bring a microphone.
Thank you. My name is Jan ter Steeg. I'm with the Ministry of Security and Justice of the Netherlands. First of all, I would like to commend Mrs. Borisenko for her efforts to improve access to justice in Russia. I was just wondering, listening to her presentation, you have several initiatives and pilots in some regions of Russia, different regions of Russia. I was wondering, how do you perceive a possible tension between, on the one hand, these several efforts, and on the other hand, the idea of equality of access to justice for all people in all regions? Thank you.
Since the law came into force on free legal aid in the year 12, the function of organization of free aid was handed over to Russian entities, regions. The federal authorities only do coordinate these activities. It has its pros and contras. The plus is the opportunity for the regions, especially for subsidized regions, to get money for financing of this activity, and they're closer to the problems of this region, and they can really provide access to justice and qualified aid at the level of the regions. The drawback is the difference of approaches in the regions, and they form different systems in the regions. That is why we've asked the government to form a committee that would include the representatives of the regions, and that committee should provide coordination of the whole system that would provide uniform approach to the access to justice, though considering the special features of the regions. That's how we plan. I believe we shall be able to summarize in 5 years when the mechanism we are forming shall work, and perhaps they will need to be modified. But that's the way the system looks like at the moment.
There's another, oh, you have a microphone. Thank you, please, person.
Good day. Notary Chamber of St. Petersburg, the Notary of St. Petersburg, Maria Tereha. Yelena Adolfovna, let me ask you the following question. Do you see the possibility to fortify the free legal aid for citizens, the opportunity to subsidize the responsibility and to subsidize the aid provided by the notaries when the citizens have exempts? We have the data that on the territory of the Russian Federation, in a year, exempts are provided to some for the amount of 50 million rubles. Is it possible to resolve this issue? I'm pleased to answer this question. We discussed this issue separately at our working group when preparing the law on notary activity. The draft law includes tax exempt for the sum of benefits provided by the notary, which in fact is the budget subsidy of this aid. So if the notary provides an exempt, then he will pay less taxes for this amount. That's my direct answer. I'm not sure whether this initiative is going to be supported, but at least the Ministry of Justice is for this idea. We're fighting for this idea. But here I see an amazing panel of speakers, and we have many conferences ahead of us, many dialogues. Like on the 11th of June, there'll be the monitoring of the use of law. Let me drive the attention of the audience to the brilliant speakers of this panel who do understand how this aid is organized in their countries. And I believe it's very important for us to exchange experience and to get the knowledge from them. Then perhaps it will enable us not to make some mistakes and to copy some useful things.
Okay, I think that if there aren't any other burning questions, it doesn't mean that we can't come back to some of the themes. I think the theme of equal access to justice is a theme that we'll be talking about the whole afternoon. That's really the overarching issue that we're all facing. But at this point, let us turn to Edwin Rekosh from PIL.net. Edwin will give us a presentation. Unfortunately, our technology has failed us. Oh, no. We're saved by the bell. So Edwin's presentation has now been uploaded, and Edwin will tell us a little bit about the practice or best practices in the US and maybe internationally.
Okay, is this, yeah. So this is unexpected. I thought I was going to have to describe for you all the beautiful images that I have on the PowerPoint, but I'm glad that I now have them to help me communicate to you what I wanted to say. So first of all, I would like to congratulate the Russian Ministry of Justice and the Russian government for implementing a very good legal aid law, which is still, of course, subject to further discussion and implementation. And you heard from the Deputy Minister how committed she is, as we know from our past cooperation, to trying to make the best of a very difficult task. which is to meet the legal aid needs of all Russian citizens. I also want to thank the Dutch government for sponsoring PILNet's efforts to analyze international best practices and to implement some studies in Russia through our Moscow office. We've had a project together with a Dutch implementer called the Center for International Legal Cooperation in Holland to study those practices over the past 3 years and to also study Russian legal needs, particularly in Samara, Yekaterinburg, and in several other cities in Sverdlovsk Oblast. And I'll mention a couple of the insights from those studies as I go. And I also want to point out that I have a report, a fuller report of our studies and recommendations here. I have a couple of copies if anyone is interested. So, okay. I won't dwell on eligibility and scope of legal aid. We have an expert on the Dutch legal aid system here with us who will be speaking momentarily, and we were very much inspired, PILNet was inspired by the Dutch experience in making our recommendations, and I think that it's true that the Russian government has also been very interested by the Dutch experience, in which first-line legal aid is provided pretty much to everyone who asks for it. And there's some reasons for it, which perhaps my colleague from Holland can go into, having to do with the administrative burdens and complex nature of legal problems that are reasons and justifications for that policy. But I won't dwell on that now. As the Deputy Minister mentioned, state legal bureaus in Russia have a particular role, especially in the pilot regions where the new legal aid law was piloted. And our conclusion in observing that implementation has been that legal aid offices are good, especially in mixed systems where they're not the sole provider of legal aid, and where, as was mentioned, non-governmental organizations are also permitted, indeed encouraged, to play a role, because there's never enough resources to meet all of the legal aid needs of any society. We know that from looking at legal aid systems around the world. And so the Russian model of trying to create a hybrid system, we think is a very good one. And in particular, as you just heard, the interest in looking at the private sector and finding ways to encourage what we call pro bono legal assistance is very much to be encouraged. Pro bono, just to define that, because sometimes people are confused by the term, it often doesn't translate very easily from one language to another, because we tend to say free legal aid, and that's an ambiguous term. Free in what sense? Free because the client doesn't pay, or free as in the lawyer doesn't get paid? And both are important in any system designed to meet the legal aid needs of the vulnerable and the poor. But we need to make distinctions, because the mechanism for implementing that legal assistance is different depending on whether the lawyer is being subsidized, usually by the state, as is the state's obligation, or if the lawyer is working without compensation at all. And we think both are very important components, because, as I said before, there's never enough resources, including in the state budget, to provide all of the legal aid that is needed. So pro bono is our term and has become globally accepted as the term for legal aid that's voluntary by the lawyers. That is, the lawyer is not being compensated, and it's considered to be a supplement. So the state around the world has the obligation to provide some minimum of legal assistance and to pay for it, to subsidize it in some form through full-time lawyers that are paid off the state budget, or through subsidies to individual private practitioners, or some combination of the two. Secondly, as a supplement but not a substitute for state-supported legal aid, would be the voluntary activities of lawyers working in law firms, in corporations, or as solo practitioners. So that's just a framework for how we use the term pro bono. The next issue I wanted to talk about briefly was quality, which has already come up. Quality control. And as has already been mentioned, we take the view that you don't measure quality by looking at results. You don't look at whether the client won or lost their case, because of course that's controlled by factors other than the quality of the legal service provided. And you don't necessarily want to look solely at satisfaction surveys, opinions of the clients, because clients sometimes are very unduly influenced by the result. They got their money back, they're happy. They didn't get their money back, they're not happy. That is not necessarily the appropriate way to measure whether they got good quality service. Rather, these are very vague standards, but these are not standards, these are sort of guidelines, insights in how you create standards. We believe that it's important to include issues of case management and recording, record keeping, and procedures, standards for client communications, basically the skill set that's necessary to provide good quality service. And if those skills and systems are in place, then often the quality, although not guaranteed, will be strongly supported. Another important insight is that it's important to look at specific measurable actions that you would expect in any particular given situation, a certain kind of a case. What actions should that lawyer have taken? For example, the lawyer should certainly have met with the client. That's one very basic one. And specific matters have specific kinds of actions that you would expect to see, written memos and the like. So that's a second thing that can be measured. Another insight is that it's important for experienced practitioners to be directly involved in developing those standards, because as we know, as any practicing lawyer knows, going by the book, the way the law is taught, or the ideal world is not the real world. And so experienced practitioners know what steps are the minimum necessary to provide sufficient quality, and they need to be involved in drafting the standards. One other issue that I wanted to mention about legal aid, use of the internet. So in the study that we conducted in Sverdlovsk Oblast, we found that 30% of the residents of the 4 towns studied already used the internet as the place where they went to find out information about legal help. So internet penetration is very deep in Russia, and that's an opportunity. And it's worth considering developing an internet resource to supplement the other kinds of legal assistance. Here on this slide, you can see a screenshot from a resource that's available in New York City, where I live. There's a very large Russian-speaking population in New York, and so in addition to the same screenshot that you see now with some Russian in it, there's, of course, an English language version, which is the main page, but it's translated into several languages, including Russian, but also other languages that are pertinent to the needs of the community in New York City. Chinese, for example, Spanish, obviously. This one happens to be the Russian page. And as you can see, it's very user-friendly and very practical. And that's the idea for any internet resource. Sometimes you see projects in various countries where people have thought of the idea, let's use the internet, it gets to a lot of people. And you see a project where someone has uploaded the entire contents of the civil code onto a website available to the general public in the name of trying to make legal information available. Now, of course, without having a sophisticated knowledge of the law, reading a statute is not going to be very helpful. So internet resources need to be very simple, they need to be practical, provide step-by-step solutions, and avoid legalese. And the Dutch have a very good experience with that, and maybe we'll hear a little about that. This is just the report that I showed you with some recommendations on it. I'll skip over that. Now, pro bono. I've already mentioned many of the things on this slide, but one thing I want to highlight, as we just heard the Deputy Minister say, there's an important role for bar associations, and not just bar associations, but government itself, to recognize pro bono. Because when lawyers are volunteering their time, not being paid, and supplementing legal aid resources to meet legal needs, they're doing it for a number of reasons, of course, including getting good experience and training, but they're mostly doing it because they care and they feel like they're contributing something back to the society. And that's more, and recognizing that fact, giving someone an acknowledgement and an appreciation, thank you for caring, is often much more valuable than a few extra rubles in the pocket. And it doesn't cost that much. So it's a very important thing to have a strategic and structured approach to that. It can really yield very important results. And then I'll start winding up by just telling you a little bit more about my organization. We're a global organization with an office in Moscow that has focused on legal aid and other topics, including the promotion of pro bono. And what we've done is we've established pro bono clearinghouses. We discovered that one of the biggest obstacles to leveraging the resources of the private sector in supplementing legal aid is that it's hard for a busy private practitioner, even if they're very well-intentioned and devoted, to find the opportunity to help. They're busy building their, many of you probably are in the private sector, busy building your practices, recruiting, getting business for the law firm, doing the legal work itself. And it's hard to take the time it takes that an NGO knows how to do of finding out what the legal needs are and how best to address them. So we discovered that setting up a very simple mechanism, a clearinghouse, almost like a brokerage, where our staff in Moscow works with NGOs that are already involved in meeting social needs and identifying their problems and helping those NGOs shape them as legal problems that a lawyer can easily provide a useful input into. And then networking with law firms and corporations that would like to get involved in volunteer legal help and present those opportunities to them and try to facilitate the connection between the NGOs that are meeting social needs and the lawyers that would like to help on a voluntary basis. And we call that a clearinghouse. We have one in Moscow, and it's been very active. Dmitry, who will be speaking to you later, has been one of the he represents one of the star law firms in that clearinghouse. I just want to mention also that we promote pro bono. We disseminate this idea throughout Europe. Pro bono practice has not been traditionally institutionalized in Europe. Of course, every lawyer from centuries ago would respond to members of the community who knock on their door and ask for help if they're a neighbor or a friend or just someone who is in need. This is an age-old ethic of the legal profession, but it hasn't been institutionalized in Europe up until very recently because law practice has changed. Lawyers now start to become integrated into larger law firms. It's very closely tied to economic globalization, large clients, large law firms. And when you're sitting in an office tower somewhere in front of your desk doing your legal work, it's hard for that client to come knock on your door, get up the elevator even, in order to let their needs be known. And so what's required is institutionalization. And large law firms like Glenn's, for example, that has offices all over the world, start to build up the infrastructure in order to make it easier on their side to facilitate pro bono work of their lawyers. And this conference is designed to try to help them to do that. So law firms come on the one hand, and corporations and NGOs on the other, potential pro bono clients. And we've done that now for 7 years, and hundreds of people now come, and it's created a community in Europe, a pro bono community of law firms and NGOs that are trying to build pro bono practice, and I hope some of you will be able to make it. It's, we don't have the Hermitage in Warsaw to give you a tour of, but we will be putting on a nice show. Okay, and then I'll go very quickly over this. This just represents our work. This is a graphic showing the 700 lawyers around the world who have gotten involved in our clearinghouses. What you don't see there are the more than a dozen or so other clearinghouses we've helped start around the world and connect together in one global network. These are the NGOs that those lawyers have assisted. One of our clearinghouses is a global cross-border clearinghouse, which is why you see more countries represented there than the countries where the lawyers come from. And then finally, this is that network that I was mentioning. These are countries where clearinghouses have been developed. You see in Russia, the dark orange represents clearinghouses that we have established ourselves. The lighter orange countries are countries where we've helped other clearinghouses get established or connect into our network. And then you can't see it very well, but there's a few that are yellow representing clearinghouses in development, including Nigeria is one that you can see there pretty clearly. So with that, that ends my presentation. Thank you very much for your attention.
Okay, thank you, Edwin, for that excellent presentation. I think that Yelena Borisenko would like to have the first comment and question.
Thank you. I'll have to leave soon, unfortunately. That's why let me note that in the hall I see many people that are responsible for the development of subsidized aid in Russia. These are the heads of our regional bodies, the reps of the Ministry of Justice and the Department of the Ministry of Justice. I'm sure everything that was mentioned shall be considered in our future work. Let me support your efforts, your initiative, and the things that you say, that motivation to assist is more frequently non-material. And for 2 years, we've taken a decision that the Ministry of Justice, when we are looking for candidates for awards for professional activities, the necessary element is the social activity of such barristers and notaries, and pro bono activity is one of the musts. So we reward people who are not just professional and successful and active. For that, they get their rewards and earnings, but we reward those that do something for the benefit of the society. This activity is incentivized by the Ministry of Justice, by rewards as well. Let me pay attention to the following. We have the examples of the United States and Great Britain, when free legal aid subsidized by the justice in case of a crisis cuts down the budget greatly, and thus qualified legal aid is becoming less accessible. It's a danger in case the financing is only done by the budget, big budget financing. That's why we're trying to form a hybrid, so that budget financing only covers the real necessities, like the criminal cases and partly civil cases. Of great importance is social responsibility of legal companies and their interaction with the government. So this is the case of the PPP, private-public partnership, which is really necessary in this field. I wish the participants a very interesting discussion, and I hope my subordinates will report me on the results. So please do torture speakers with your questions. Thank you.
Okay, so let's open it up for a few questions for Edwin Rekos at this time. Yes, please. Someone has a microphone over here.
Работает вроде бы, да?
I have a question to Mr. Rekos. Please introduce yourself. Pavel Blokhin from the Constitutional Court of Russia. I have a question to Mr. Rekos, practical question. Well, you've mentioned that system of online assistance via internet, and you offered to use that system. I've been to such offices in Hague, for example, several times, where head judicial locus, that's the way it's called in Dutch, when this legal assistance is provided. And I've heard that they have not only that internet system, but they also have special call centers or something of this kind. When you you can make a phone call, and the primary assistance shall be provided by the phone when the expert will answer certain questions, and then step by step you may get to a certain answer to the questions. Also, in the internet, there are special programs, software. The principle is that you have to answer certain questions, and then via internet, the software will direct you and provide a certain legal advice to you. This program seemed to work only on civil cases, and it was mentioned that they are planning to make the same technical things for divorce cases, for labor disputes, and other fields of legal assistance. To keep developing, have you invented any other technical appliances that could be helpful in my country as well? Let me tell you, in Russia, we are also trying to implement such things. I know that legal companies, private companies, with their own money, have formed the text message application that if a consumer had problems in the shop, he could text message or call, and step by step, by answering certain questions, he could solve the simple problems related to products and services. Thank you.
Yes, thank you for the question. My colleague Herman might have something to say about the specific Dutch system, but let me preface that by saying that I don't want to be misunderstood about my point about online systems. Certainly, hotlines, as you're mentioning, telephone hotlines are very important, and also online systems which provide specific answers to specific questions. But my point about the online resource that I was talking about is at a higher level. It's basically, I don't have the slide on there now, but the project that I was presenting is basically a referral system. It's meant to put in one place, which is what the internet is so valuable for. It's basically a portal or a hub, one place where someone with a legal problem goes to find legal help. They don't have to know that their matter is a family law issue, or their matter is a landlord-tenant issue, or whatever ways lawyers might have of dividing up their issues, property rights, contract rights. They don't need to know that. They just know they have a problem. And then they go to this one central page, and it gives them easy to navigate categories that are obvious, that are plain English or plain whatever language. And when they click on their category, they simply find the existing resources that are already there regardless of technology. So they would get phone numbers, or they would get offices to go to, or they would get online resources if they exist in that particular issue. So really my point was the most important thing is to use internet technology to create that kind of way in for the client, that portal, where then they can go and find everything that already exists. Now, on top of that, of course, you can develop the more specialized online resources like what you were referring to. And I don't know if Herman wants to add something about what the Netherlands does.
In my presentation, I will tell something about the Dutch experiences with online help. There was another question here in the front.
Thank you. I'm Ruben Menikian, Deputy Minister of Justice of Armenia. First of all, let me thank you for very interesting presentations. I had an opportunity to listen to Mr. Rekosh several years ago, and I'm pleased to see him again at the forum in St. Petersburg. My question is regarding pro bono system. I know it's a system that Mr. Rekosh and his associates are trying to make global, and even that term that they've invented is being used by everybody, the pro bono term. But are there any risks regarding this system, regarding the tax bodies? Did it ever happen? I believe you have monitoring of the issue in different countries. Did it ever happen that the tax bodies believe that this system may provide opportunities for fraud?
рассмотренным делам, что на самом деле это не pro
The
bono, но пишется pro bono,
cases
чтобы
are mentioned as pro bono, though they have been paid, just to avoid paying taxes.
Бывали ли такие риски или такие?
Did it
Очень
happen?
конкретный вопрос и хотел бы знать конкретный ответ.
Please give me a precise
In fact, it's not
answer.
only relevant in a situation where there's a fraud being perpetrated, in other words, where purportedly pro bono services are actually being paid for and the income is being hidden, but even more importantly in situations in which the pro bono services are being accounted for, as already Edwin mentioned in his presentation, as legal services. So in other words, the law firm is insisting, and rightfully so, that their lawyers record their work, that follow the same standard procedures for client service, that the memoranda or advice be reviewed by counsel, and it then becomes quite easy to, for instance, the tax authorities of a given country to come in and say, well, wait a second, this is a paid legal service. You've waived the fee for a particular client, but that doesn't mean that the service wasn't rendered, that had a value, and consequently, for instance, you should pay a VAT on that. So this is certainly an issue that's come up, and not yet, I don't think, in Russia, as far as I'm aware, although Dmitry will comment on that. At any rate, so the issue is broader than just fraud. The issue is, even if there's no fraud at all, unless there's a statutory solution to this, isn't there a risk of taxation?
Yeah. So, first of all, I would love to take credit for inventing the term pro bono, but we didn't do that. But what we did do, pro bono has existed for a long time, particularly in Anglo-Saxon legal jurisdictions, roughly 50 years in the US. And I think what we did is we figured out how to universalize that. We figured out how to adapt that terminology to fit other jurisdictions as it appropriately does. And we've disseminated that idea. So I think what we can take credit for is disseminating. Yes, as you asked and as Glenn has emphasized, there are some potential regulatory obstacles to pro bono. Those are the key risks. We have a couple of colleagues from Germany who I expect are going to be addressing the German perspective on this, where that's come up. In addition to value-added tax issues, which has come up, I don't think it's come up in Germany to my knowledge, but it has come up as at least a risk in a couple of other jurisdictions, like in Poland. And so that's one problem. And then a second problem is that it's sometimes considered to be anti-competitive practice to give away your legal services for free. Of course, that implies that you're giving it for free to a client that's willing to pay big money for client services in hopes of attracting even more money. That's the anti-competitive idea, which our German colleagues, I'm sure, will elaborate on. That doesn't apply for poor individuals, of course, or for NGOs that have limited budgets. But those are definitely risks that are out there. And our approach, maybe I'll leave it to our German colleagues to elaborate in more detail, in more practical ways on those questions. But our approach has been to try to shine a light, as Glenn was doing just now, on the problems and to foster debate and discussion, because reasonable minds are not likely to differ on what the appropriate approach in a regulatory sense is to those issues in pro bono practice. It's just that they're novel issues in many jurisdictions because pro bono practice wasn't well developed before, and it needs a little time to percolate and for different legal cultures to address those issues in different ways.
Let's have one more question at this time in the front row. Already has a microphone, and then we'll go on to our German speakers.
Yes, I'm Paul Albert Rivas. I'm former president of the French Bar Council. I was very interested by your presentation, your programs. Looks very nice. But I would like to say that, first of all, access to justice is a right for citizens. It's not a gift from gentle lawyers. So beware when government says that's a very good idea, because it's first the duty of government to assume access of justice. That's all.
Okay, so I strongly agree with your statement, and I'm familiar with the French legal community's approach to this issue. We organized our forum, our pro bono forum in Paris about 3 years ago, and we had the great good fortune of having the then bâtonnier attend and present, and I won't give you my view, but I'll quote him as saying that, of course, repeating your very important words about the duty of the state to meet not just the access to justice needs of the society, but all of the needs of the society. But in his words, the world is getting more complicated, and the state can't do it alone. It can guarantee a certain standard, but there's always more needs. And the private sector involvement can be useful as a supplement, again, as I emphasized, as simply not just adjunct to the state's obligation to provide legal aid, and as an important added resource, because there are so many needs that no government has enough resources to meet every single need. And of course, we can go through, if we had more time, we could go through examples that I'm sure you and I would agree on of gaps even in the French legal aid system.
Thank you very much for that question, and let me now turn. We're very honored today to have the president of the German Bar Association, the German Federal Bar Association, with us, Axel Filges, and you've already been given certain information about the German system, but not from the mouths of practitioners. So now let me turn it over to the head of the Federal Bar Association, who can give you some insight into the way that the system of legal aid is administered in Germany and the issues that raises.
Thank you very much, Glenn. Please let me start with a joke. Have I got it correctly? The abbreviation of your organization is PILNIT, not BILNIT.
PIL,
Okay,
PIL, yeah.
Just the difference between P and B.
Yes,
Okay,
it's a big difference.
Okay. Whatever this means. Liebe Kolleginnen und Kollegen, insbesondere liebe russischen Kollegen in
I'd
dieser
like to greet
Runde.
Russian colleagues in this hall. As Glenn presented me, I'm the president of the Federal Chamber of Barristers, not association, but chamber. Thus, I represent all the 160,000 German lawyers of both sexes. And I'd like to use this opportunity to inform you that all German lawyers are always pleased to come to Russia. We expect a close cooperation with the Russian Federal Bar, with Mr. Semenyaka. We keep meeting regularly at different events. We socialize with each other. German lawyers believe that we played a certain special role after the reunion of Germany in the year 1990. In Germany, next to each other, there appeared two very different systems that needed to be united. My colleague Adman is representing Brandenburg, that's the former East Germany. Yesterday, he mentioned that we have certain unique experience of unification of two systems. Thus, we are a link between the colleagues from Paris, Great Britain, and Russia. I keep saying, when you come to Berlin, from Berlin, it takes the same time to fly to Moscow as to London. I think it's important for our common activity. Now, getting to the topic of my presentation, I'd like to tell you about our system. First of all, let me tell you the following. That's what I got from the last discussion. I'd like to tell the young colleague from the Constitutional Court. I'd like to explain the complexity and comprehensiveness of legal issues. You've said that in a shop, when making a purchase, you may send a text message to get legal assistance regarding certain products or goods. I worked for 35 years as a lawyer. Thus, I represent the older generation of lawyers, and I believe that legal issues most frequently are much more comprehensive than you can imagine, and they can't be addressed with just a text message or with clicking of a computer mouse. People that look for the lawyer's assistance are usually in a very difficult family situation, or they have a certain legal problem. They are in a special situation if they need the legal assistance. They need to trust their consultant. They need to form personal relationship with the lawyer. They should explain every detail of their case, and even such simple issues as the issues of firing cannot be addressed with a text message, because each federal district of Germany has a lot of special rules in this regard. So if we talk about a system, if you want to organize the legal assistance in the correct way, you first of all should understand that it's a comprehensive thing, and you can't solve all the issues by just clicking the computer mouse. My colleague Fischer will later tell you on how German lawyers are working in the field of legal assistance. But let me begin with the following. We have a different system in principle. The government task is to provide access to justice. And if it's a hybrid system, and if the state and private parts are adding to each other and are mutually beneficial, first of all, you have to agree who is the main part, who is the main player. This function may be taken by the government, as Madam Borisenko mentioned, or this function may be transferred to private bodies, and then the government will be just an addition. Access to justice in Germany is something that was influenced by our history a lot. And here in St. Petersburg, it's very important to mention it. This is related with the existence of the state. Why do we have the state, the government? Why may the government require that their laws and regulations are obligatory for citizens? Why does the state have some power or monopoly for power? The reply is very simple, the way we Germans understand it. The task of the government is to provide the freedoms and rights of persons and protection of those things. Thus, authority is not something that goes for granted. It's due to the government that freedom and rule of law become possible. Thus, they're allowed to have that power, and that is why citizens do not carry out justice themselves in exchange for providing of freedom and rule of law. And this is carried out via the system of courts on all the territory of the country. These are independent courts, and the advocacy community should be independent as well. At the recent event organized by a Russian bar on Tuesday, Madam Borisenko, in her presentation, clearly mentioned the following, and it's for the first time that I heard this from the representative of the Ministry of Justice. She said about the following: no state, no government in the world may be interested in advocacy which is governed by the state. These are very courageous words. I underline them and I fully support them. But if the government is not interested to have the advocacy governed by it, it cannot be interested in legal advice or advisors that shall be governed by the state. That is, as far as I understood the Russian situation at the moment. At the present, non-lawyers have the right to provide legal advice for citizens. As Germans, we don't understand such a principle. It seems contradictory, since thus the interests of the state are being violated. And even the best justice system and litigation system will not help if, due to the lack of finances, the person can't get access to legal aid. In the beginning, the Constitutional Court was dealing with these issues. It was protecting the main principles of the Constitution, and they decided that the citizen should have the right for legal aid guaranteed by the state. And this aid should be government aid. And if somebody doesn't have finances to protect his rights, according to Constitution in our state, the government should provide, and it's a must, to let him protect his interests at the expense of the state. In practice, it happens this way. In both fields, both legal advice and court litigation, a decision is taken on according to different criteria. For example, it depends on the income of the citizen, whether he can claim government legal assistance or not. Such things exist in different systems. It may happen that at present the person can't pay for the lawyer, but he may probably be able to pay in parts later on. Thus, he is first provided a lawyer, and if he wins the case, then from the money he gets in this way, he'll be able to pay to the lawyer later. I'm quite proud of the legal system we have in Germany. In the international rating, we are second after the Netherlands regarding providing access of citizens to justice. That's according to the Journal of Law magazine. But let me add something bad about ourselves. Of course, we are very proud of being second in this rating, but now we are concerned we may lose that second place because some modifications are introduced into our court legislation, and our bar was against those modifications since they are planning to bring down that income amount, and that means that the government is trying to save some money on this. It happens in all the countries since governments have less and less money, and Madam Borisenko fairly mentioned that this is one of the challenges for our system when the government is beginning to save on providing legal advice, and they start to save on, say, music education and legal assistance. Well, we have such a comprehensive system of litigation. That's one more peculiar feature. Now let me get to the topic of the role of the barrister. After the barrister gets, say, the ticket for the legal advice that he should provide, legal assistance. He does it at the expense of the state, but for a smaller fee than if he worked privately. That means that those 160,000 lawyers of Germany are obliged, according to their professional code, to provide a legal aid with a great discount in such cases, and they actually do it well out of their pocket at their own expense, and we may require this from them, since they are not just the sellers of their services in the supermarket, they are protecting justice. Thus, they guarantee that the system functions. I can see that our Dutch colleagues are already reacting to my words with gestures. They say it's not quite so, or perhaps not quite fair. Well, this issue is related to certain segments. The cost of legal services or legal consultations is usually done by small legal bureaus. You may refuse, you may say, I'm too busy, or I'm not an expert in this field, or I'm busy at the moment. And frankly speaking, that if you're praising a certain system, you should point at its drawbacks and mistakes as well. The result is that big law firms in Germany, like big international firms, are not active enough in this field of government legal aid, and this is a mistake. If barristers do not provide this type of assistance, this is bad from the ethical point of view. I believe that they should work pro bono, and as the representatives of 160,000 lawyers in our program regarding the ethics of advocacy, we were studying the pro bono activity of barristers. We know that our Russian friends are also thinking on how to formulate the code of ethics, and we recommend you to remember that, well, we know that ethics really is important for the activities of lawyers and their life as well. It also includes the barrister's behavior in private life as well. In our country, it's different. The lawyers' rights and obligations are well described in the professional code, but as for the unprofessional life, there are no additional ethical norms for private lives. Anyway, they're not registered anywhere or written down anywhere. In fact, it's not quite so. In Germany, we believe that one should always consider the so-called free professions, because the free profession may only be limited by legislation. As for all the other spheres of life, we shouldn't limit the free professions with the spirit of time. And I believe the ethics is the spirit of time. That is why we're very careful about this discussion in Germany. But where we are not so, we're quite brave, is the professional ethics. We believe that if barristers do not participate in state legal assistance, then they should provide pro bono services. Now, summarizing the German position, pro bono, yes, definitely yes for pro bono, with the support of the bar, but it shouldn't replace the subsidized government legal aid subsidized by the government. We have a discussion in Bundestag, and we are concerned that the government assistance shall be cut down. They will say that barristers might take care of that. Thank you for your attention.
Colleagues, I think what we should do at this point is, rather than taking questions specifically to Axel's presentation. If we could now go to our second German presentation to give us the sort of full picture of the German picture. We're very lucky also to have Matthias Fischer. Matthias is of counsel to Latham & Watkins law firm, but today he's here in his other role as a member of the board of Pro Bono Deutschland, and he's also a co-founder of Pro Bono Deutschland. So Matthias, the floor is yours.
So, thank you, Glenn. Thank you, Glenn, for this nice introduction, and thank you to the forum for inviting me here. I feel honored to be able to speak here among these other distinguished speakers. As Glenn just said, I'm not here, although I'm a litigator at Latham & Watkins. I'm not here as a representative of Latham & Watkins. I'm here as a representative of an organization called Pro Bono Deutschland, which can be translated into Pro Bono Germany Association. It's an association that was founded about 2 years ago by a couple of law firms in Frankfurt. Since those 2 years, a number of other law firms, like in different size, have joined our association. And we have also branched out to other cities. I mean, we started in Frankfurt, which is like the hub for the large law firms in Germany, out to other cities like Hamburg, Berlin, and Munich. It's what this association wants to do is we want to achieve greater recognition and a more widespread implementation of the concept of pro bono in Germany. Our association is committed to the principles of social justice, democracy, and the rule of law, and in particular the recognition of human rights. So in short, we want to promote pro bono. There are some of the largest law firms are members in Pro Bono Deutschland, like Freshfields, Clifford Chance, Linklaters, L&O, Skadden Arps, Sherman Sterling, Mayer Brown Deckard, and Latham & Watkins is one of the founding firms. And I'm on the board of Pro Bono Deutschland. So I think what we have already heard today is that a private practice pro bono program cannot replace state legal aid. Both things are about something that is totally different, and that's why it's not in competition. And legal aid cannot replace our pro bono programs, and we cannot replace legal aid. Legal aid is a form of state welfare assistance. So for people that cannot afford a lawyer, at least that's the way how it is in Germany. The government comes in and pays for the lawyer. So lawyers that work for legal aid mandates do not work pro bono. They get paid by the government. And in contrast to that, pro bono programs means that the lawyer does not get paid at all, or the law firm does not get paid at all. As Mr. Filges already mentioned, in Germany it's quite common for small law firms to have a practice that is financed by state legal aid. And the number of lawyers that have a significant portion of revenue coming from state legal aid is quite huge. So these lawyers, so a large number of lawyers deals with a large number of cases for state legal aid. So the big law firms in Germany or around the world might seem big from the outside, but if you look at the number of lawyers that work in these big law firms, the number is relatively small compared to the whole legal profession. So if we devote a portion of our time to pro bono work, it is relatively to the amount of work that's being done for state legal aid relatively small. So and so if we look at a country like let's say, for example, the United States, that does not have a comprehensive state legal aid system. But law firms have tend to have fairly big or huge, sometimes pro bono programs. The number of people left behind and that do not get legal protection in certain situations is much bigger than in a country like Germany, where access to justice is much easier than in the States, although the law firms have such a big and established pro bono practice. However, in Germany we do practice pro bono. We have not been doing it for so many years, so everything like the whole pro bono culture in the Anglo-Saxon countries altogether is much more developed than in Germany. So that's why we have this pro bono Germany association, so that we can talk to each other and exchange ideas and find out what we can do to grow the practice. But so far, the pro bono legal services from the private sector have a strong focus on NGOs. So let's say someone wants to establish an NGO. That is quite hard to do without a lawyer. For example, these NGOs need to be granted charitable status for tax purposes. So their charter has to be structured in a certain way. So we often do that. And then sometimes these NGOs also go bankrupt, and then we help them too. And there are a lot of NGOs that have a focus that has something to do with law. For example, I can only refer to one of our clients. They represent children and parents of pupils that have disabilities. And we have a system in Germany where we have schools for children with disabilities and schools for children without disabilities. And this is a violation of the UN Charter on the rights of people with disabilities, which requires that children with and without disabilities need to be schooled in one school. So what we do for these NGOs is we do lobbying work, we do draft legislation, we appear on press conferences, on forums, not legal forums, but like school forums, stuff like this, and represent these organizations' legal view. So I think that is a typical project that falls within a pro bono program. It's not specifically designed to help the poor, because the children or the parents of these children with these disabilities might not be poor. The ones that I have met so far were not poor, and they had an own lawyer, but we were still able to help them and help the organization. How do law firms get pro bono programs running? That's another thing I wanted to talk about. It's not always so easy, and there are several things that are crucial. I mean, if there are smaller law firms or sole practitioners, they might often be asked a favor, and then they work for like someone who cannot afford for a lawyer, I don't know, maybe for free, or for an NGO that is like through a friend or something, and or through a friend that he does not want to turn down. If you work for a lawyer, if you work for a larger law firm, you need to, then that is very important. You need to institutionalize the pro bono program, because if you do not institutionalize the pro bono program, either no one does pro bono work, or it gets out of control. And what is another thing that's very important is that you need a strong support from the firm's leadership. So the firm's leadership needs to take lead in the pro bono program and needs to support or needs to define some standards. So we have, I think that most of the large law firms have that, quantitative as well as qualitative standards. Qualitative standards. It's tempting to label a certain type of work pro bono when it might not be pro bono. For example, a partner is a member of a golf club, and the golf club has a dispute with its neighbor. The golf club might be rich, but still the firm does it but the golf club does not want to afford like the top-notch law firm. So maybe the law firm might step in and do not write a bill. But that's not pro bono according to our standards. If one of our lawyers wants to do that in his free time, okay. But that is not the kind of pro bono work that is defined as pro bono within our pro bono program. So we always have a focus on helping the poor, on promoting human rights, or helping NGOs whose funds would be depleted if we would not help them. So these are some of the qualitative terms. It's like if we decide whether we want to devote our resources to a certain matter, I have like several pages of very fine print I have to go through to check whether something qualifies as pro bono or not. The other thing is quantitative. You also want to make sure that pro bono does not want to get out of control, because of course, most law firms are commercial enterprises, and if you want to continue to exist, nothing can get out of control in your firm. So you have to just want to control your pro bono program. On the other hand, it's also sometimes there are certain offices or certain people that are not interested in practicing pro bono, and still you want to have some involvement of a large number of people. Also, you want to have, when you say you have a pro bono program, you want to make sure that this is not just lip service, but that you have a substantial pro bono program, and therefore minimum standards are also very important. So running a good pro bono program is not easy, and it takes a lot of commitment and hard work every day. Thank you.
Thank you very much, Matthias. At this point, I think we will open it up for several questions from the floor. Please.
Скажите, пожалуйста.
Could you tell us, please, according to German legislation, if a person is arrested for a crime, does he have a right to call his lawyer or to get some other connection searching for a lawyer? According to Russian legislation, if a person is arrested for a crime, he cannot have any communication, including communication for searching for a lawyer. That's my question number one. And the second question is regarding the payment of the lawyer's work. According to Russian legislation, if the lawyer participated in the litigation and he was appointed by the government, then in case he lost the case, all the expenses are the burden for the accused person. Is it the same in German legislation? Thank you. I'd like to hear the answer from the last speaker.
Да-да.
Yeah.
But I'm not sure it's the correct protocol that the questioner gets to determine the...
Question number one. I'm not a criminal lawyer. I'm not a criminal lawyer. I'm not aware of a problem regarding your first call to a lawyer. And the friends of mine who practice in criminal defense have never told me about the problem concerning that problem. Number two, that's also how it works in Germany. If you are the loser in a criminal case the loser in a criminal case has to pay for criminal defense, which can be a problem when he comes out of jail, because he may be because they may have accumulated a lot of debt. So he comes out of jail, has a lot of debt, and then that may be an extra burden for reintegrating into society. Yeah.
Moscow City Notary Chamber, Notary of Moscow, Uliana Novopashina. It's a pity that Irina Adolfovna has left, I mean the Deputy Minister. Nevertheless, I have a question regarding your practice. Usually it's poor people that apply for such services. They have no money, but in my practice it happens, and it happens in the practice of my colleagues, notaries. People frequently have are getting the title when inheriting huge inherited properties. This right is guaranteed by the state. They're not paying for the notary services when acquiring huge inherited properties. Is it possible in your countries? If multi-million inherited properties are received, are notary services free in such cases? I understand that it's funny, but I'd like to clarify. I'm talking about protection. If a guy has no money to pay, that's one thing. I thought there are free notary services provided in different countries. That's why I'm trying to specify this issue. I'm giving you the example of what happens in Russia. For me, it's nonsense when a person getting money also gets from the government to get notary services free of charges.
I will allow the question to be asked and answered if our speakers can answer it, but I should point out that as in Russia, I believe Germany and in most legal systems, the rights and obligations of notaries are separate from those of lawyers, and the speakers here are lawyers and are not specialized in notarial business, so I'm not sure that they have the requisite expertise, but if either of you would like to comment, please.
If someone in the Netherlands can't afford a notary, he can apply at the court. He has to fill an application form, and he has to prove that he has no money. We don't have the phenomenon that a notary works for nothing. In these situations, you still have to pay half of the cost. That's how it's regulated in the Netherlands.
Certainly, I think if one looks at the broader issue, which was covered to a certain extent by Edwin in his presentation, there's always an issue of how one defines the class of individuals who are entitled to subsidized legal services, and then how one implements that decision. So in other words, how one implements the mechanism of determining that a person qualifies for the subsidized legal services. So that certainly is always an issue. Axel?
Eine kurze Anmerkung nur dazu.
Small remark in this regard. I probably wasn't clear enough. All the government provision of access to legislation is already regulated by legislation. In Germany, it is regulated by legislation. We have a law on legal assistance, legal aid. Judging by your question, it's related with comprehensiveness of legal assistance. Sometimes it's difficult to tell whether the person in general or temporarily or partially is entitled for free legal aid. For example, if somebody is protesting against his own firing and he wasn't paid a salary for 3 months and now he has to get legal assistance, after winning the case and getting the money, he is supposed, first of all, to pay for the legal assistance he once received free of charge. It doesn't mean that his employer has to pay for the legal services. So the whole system is closely related to the actual need for legal aid. We also double check the income rate of the persons. Sometimes after 5 or 6 years, lawyers are revising the old cases because the courts are asking them. They say, some time ago you represented Mr. Filgas. He was bankrupt at that time, but now he was financed with 10,000 euros. Well, we once provided services to him free of charges that were worth 10,000 euros, but now he has good money and we should charge him for the previous free services. If somebody doesn't really need it, means he is malusing the free legal assistance. Yesterday in Bundestag we discussed on how to avoid the malusage of free legal aid. People are actually trying to get some social services free of charges, for example, to get welfare, etc. So everything free, people take with pleasure. And in a free society, it's necessary that people watch that there's no fraud like this happening. And that's what we do now. We do the control.
I'd like to ask a question.
To my mind, the way out, using Russia's example, or it could be in a different state, would be a center that would state the right of this person for this subsidy. He would apply to a certain center, get a document. With computer aid, it's possible. You can trace all the person's income, and then he would get the right to apply for free help. In Russia, there's the right for free aid. If you present, say, certificate that proves that you are handicapped, but that handicapped person may be having quite a good income to be able to pay for this service, for the legal aid or whatever, for the notary service, because the government declared that the task is to protect the poor and not to redistribute the benefits.
I think that Edwin will take a stab at answering
it
this
to be an unfair
question.
system.
It's on. Okay. So, of course, notarial services and legal services are different. But you have the same question with legal services, and the question is, how do you determine eligibility for legal services, especially because in many places, in most places or many places in the world, it's quite easy to hide your assets if you want to. at least to some extent. And so what we found in the case of legal services is that in most cases, it's at least to some degree self-regulating, because the quality of legal services are not such in a free legal assistance scheme that someone with significant assets is going to gain from fraudulently seeking free legal services that are theoretically for the disposal of vulnerable people. And it doesn't happen. Of course, it happens, but it doesn't happen that much in most jurisdictions. And in addition to that, there's also the question of the administrative burden as a policy matter, because to really be thorough about the checking on assets is extremely burdensome. And one risks that for every one fraud doer who is caught fraudulently seeking free legal services, you have 100 people who are deserving and needy, who are discouraged from even trying to get the service. So there's a balancing act, I think, often in devising legal aid policies. I think that the Netherlands has confronted this issue, and maybe we can hear about their solution. But my view is that it's important not to be careful. Of course, we don't want this important resource to be abused, but we have to be careful to make sure that it's used by the majority of the people who need it. And often in a place like Russia and other countries, there's a problem of public trust in the system. And if you make it too difficult to access, it could be a bigger harm than to cut out the fraudulers.
Before I turn the floor over to Axel, I just want to say that there are many practical issues with the solution that you've proposed. So one issue is if the determination of eligibility is made at the time of the client turning to the lawyer or presumably to the notary, then you can check the financial status of that individual at that moment in time, because financial status, of course, changes. And it seems to me unlikely that someone is going to go to a federal agency and establish that they're very poor just for the sake of having that designation. It's only at the moment where they will be seeking some type of a service that they would want to do that. So it seems to me that the method of intake, for instance, I had the experience as an associate at Cleary Gottlieb Steen and Hamilton in New York of being seconded for a period of 6 months to a legal services corporation, which is a public corporation, a federal corporation in the U.S. that manages civil litigation for indigents. And in addition to lawyers, we had a number of social workers, and we had guidelines, and the social workers would intake the clients, determine eligibility before the clients were turned over to a lawyer. And this was, of course, it isn't as simple as what Edwin said, because it wasn't a question of determining whether the person was rich or wealthy. That's often obvious. The standard for receiving free legal services funded by the Legal Services Corporation is extremely low. Only extremely poor people. So if someone had a landlord-tenant dispute and was very poor, but not in this extremely low category, then it was indeed something that they would end up being turned away. It's not a universal system. So it's something, it seems to me, I tend to agree, though, with Edwin, that it's certainly not something that I would want to see the government making a designation of, you know, here you have a little thing in your wallet that says I'm an invalid. This is something that presumably you have from birth or from the moment of an accident, and has a lot of other ramifications in terms of receiving social funding. But for someone who's poor, this can happen because, for instance, the crisis hits and you're laid off. So it's something that needs to be assessed at the moment when the person comes into a legal services office or seeks legal assistance. And let me turn the floor over to Axel.
Ganz kurz nur diese Frage. Ich bin dankbar für die Frage.
Thank you for the question, since this question explains how different are our systems. In Germany, we have the federal system. After the reunion of Germany on the territory of the former East Germany, we've restored the old federal districts. We do not have a center like Paris in France, where they decide whether in Munich, Berlin, or Lübeck somebody needs free legal aid. They're too far to make decisions. So the judge presiding the process takes the decision on whether the claimant can get free legal aid at this litigation. The judge takes a decision basing on legislation and forms that the claimant needs to fill out, where he mentions the size of his income, etc. I believe that's the actual way to be objective and fair in each case. I believe that's the right system, so that in a certain litigation, certain person at a certain time may be provided free legal aid. He shouldn't be rich or poor in principle, but at the moment in a certain life situation of a certain person. The second point that proves the systemic difference between us, and Glenn mentioned that from the point of view of the USA, the system of Germany cost taxpayers hundreds of millions of euros per year, and the free legal assistance of the government is provided not only to really poor families. It may be provided, say, to a husband who is supporting a family. He has a job and supports the whole family. His wife may not work, children may study. These people may have their own house, they pay for their housing. From the economic point of view, the situation is not that bad, but their children are studying, they need to spend money on their education. The husband works, the wife does not work, she's unemployed. Well, so from the social point of view, they are not in an extreme situation. But they may say, no, we can't afford a lawyer. Thus, we refuse our rights for legal assistance. For them to not do that, they are provided legal assistance for free of charges. Or perhaps there's a person who can claim his heritage, the heritage from his father, but he cannot afford a process. He say needs to pay for his university education. And in Germany, we believe that this person should have the opportunity to participate in this expensive litigation, and we provide assistance for such a person as well, though he may not be impoverished at all. We believe it's a correct approach.
Okay, I think at this point I'd like to switch back to the Russian context and turn the floor over to Dmitry Samigulin. Dmitry is managing partner of RBL Law Firm, which is one of, or perhaps the largest law firm in the city of Samara in the Volga region of Russia. And as Edwin mentioned, Dmitry's firm was one of the firms active in the pilot program for pro bono legal services in that region. And indeed, as an illustration of one of the incentives that the moral incentives, or the, I guess in a way it's even more than a moral incentive, Dmitry's firm received an award for their participation in this program from the journal Legal Insight. So let me turn the floor over to Dmitry.
Thank you very much, Glenn. Excuse me, colleagues, my presentation will be in Russian.
First of all, I'd like to thank the organizers of this forum for organization of this roundtable talk and for their interest to free legal aid. At the last legal forum, there was also a roundtable dedicated to pro bono, and it's a great honor for me to participate in it, to the most important roundtable talk of this forum, as Glenn mentioned. First of all, let me say that, to my mind, this topic of free legal assistance is an international topic, and it's actual for lawyers from different countries, including Russia. Lately, the government of Russia is paying a lot of efforts to organize free legal aid access, and it is only being formed. Even the law mentioned by Madam Barasenko, the law on free legal aid in Russia was only adopted in the year 2011, and less than half of entities of Russia have adopted the original laws on this same topic. Nevertheless, you heard today that some things are being done. The Coordination Council was created at the Ministry of Justice on the development of free legal aid. Some ethical standards are being developed of professional activities. That's pleasant to hear, and we can state that in a brief period of time, there has already been formed a certain number of tools, rather many tools, of providing free legal aid, and a lot of bodies are involved in this process, like the state legal bureaus, the project carried out in certain entities of Russia, the legal clinics, the advocacy, the notaries are also involved in the system of free legal aid. And I can even give an example, bright projects carried out in certain entities of Russia. The project on providing of free legal assistance. A good example is the example of Samara region. It was called Coordination of Activity on Providing of Subsidized Legal Aid to the citizens of Samara region. Why was it interesting? Why should I mention it? You asked about call centers and gave the example of the Netherlands. This project is very similar to what they do in the Netherlands. The essence of that project was signing by the bodies in the region of an agreement. The government of Samara signed it, the Ministry of Justice, the Association of Lawyers, the Bar Association of Samara region, the State Legal Bureau of Samara region, and thus these bodies have agreed on the conditions of providing free legal aid on the territory of Samara region, and on the basis of the ombudsman there was formed a uniform call center which accepted all the calls from people who needed free legal aid. Experts of this call center analyzed these calls and, first of all, decided on whether these people are eligible for subsidized legal aid regarding the criteria of regarding different criteria mentioned in legislation, and if that call or requirement was considered eligible for providing of free legal aid, then it was distributed between the bodies that have signed that agreement, and thus that client was sent to either the Bar Association of Samara region or to the Government Legal Bureau, or it was solved by the experts of that call center. It's a very interesting, innovative example. And now this practice has been supported by different regions. I know that in Ulyanovsk region they have a similar coordination council, which is supported by the governor of Ulyanovsk region, who is very enthusiastic about the development of free legal aid in his region. It's a very good example to be followed. As for the pro bono practice, it's a bit more complicated. In Russia, we have different attitude to pro bono. I was kindly invited by Pilnet to participate in the European pro bono forum last year in Madrid, and I was asked to make a presentation at the round table called Pro Bono in Developing Countries. Before the round table, I've told my colleagues that very name of that round table talk is describing the condition of pro bono. So we were in the same company with China, South Africa, Brazil, and forgot the other countries. So we were in that group, developing countries, as far as I understand, not from the point of view of economy, but from the point of view of pro bono development, not the economy of those countries. Let me tell you what questions were discussed and what we should pay attention to. Unfortunately, at present, pro bono culture and practice is not a mass practice among the laws of Russia. For the following reasons. There are no obligatory standards and norms that would oblige the lawyers, the barristers, to conduct pro bono practice. Second, unfortunately, we frequently encounter negative attitude to pro bono on behalf of our colleagues, practitioners. This is probably an obstacle for development of pro bono in Russia as well. Nevertheless, I may state that gradually the situation with pro bono is changing in Russia. I have this conclusion. It's based on my talks with my colleagues. I can see that there appears some interest. People have brighter eyes when pro bono is mentioned. And the number of companies is growing that do cooperate with Pilnet Russia. At present, some 18-20 Russian legal companies, firms that constantly cooperate with Pilnet. That means they do accept the Bono project permanently. Another interesting point, if last year the number of international legal firms working on the territory of Russia and cooperating with Pilnet was higher than that of Russian legal firms, now this ratio is roughly 50-50. I'm pleased to learn that our Russian colleagues, lawyers are interested in pro bono work, and these are companies from different regions, not only Moscow and St. Petersburg, it's also Samara, Rostov-on-the-Don, Voronezh, and other places. I'm pleased to mention it. And one more important point about pro bono. I believe the government should do more for the development of pro bono practice in Russia. It's obvious that only subsidized legal aid cannot satisfy all the needs existing in the society. So the government should promote pro bono practice and incentivize it. Among the key problems that I'd like to discuss with the colleagues and to mention are the following. First, the problem of quality of provided legal assistance. It was mentioned before from Madam Borisenko, and it's really an actual problem. I haven't invented it. European Court on Human Rights mentioned this problem as well in some decisions. It required that the government bodies control better the quality of provided legal assistance. It's because people who are provided free legal aid do not have the opportunity to control the quality of this aid. That's why the European Court on Human Rights paid attention to this issue. I believe there's no uniform way of solving this problem. It's a comprehensive problem. Thus, comprehensive different tools are necessary for its solution. First of all, I believe uniform quality standards should be developed for the activity of lawyers in Russia. So far, there's only one obligatory ethical standard, that is the Code of Professional Ethics of barristers, but it's only obligatory for barristers. The other way to influence this problem is correct organization of pro bono activities. At least the right making out of an agreement, the contract for pro bono services should be made correctly. Quite often projects are carried out, a needy person is provided some assistance, but it's never mentioned in the documents. There should be contractual relations. It's a deal, actually. So everything should be properly documented, and rights and duties should be mentioned in that contract. This could improve our opportunities of control, of quality control. And the second problem that I'd like to mention is the problem of legal education. It also influences the level of free legal aid in Russia. I'm not talking about legal clinics that we know of. They also provide free legal aid. I'm talking about modification of educational programs in the field of legislation, when future lawyers are taught to be socially responsive. Right now in Russia, they are trying to introduce in the system of education courses or certain subjects or some lessons dedicated to the standards of activity, ethical standards, and in a number of higher educational establishments they teach that, but this should be universal and obligatory in all the systems of legal education. This could help us solve the problem. This is my personal opinion. And I would like to hear your response to my opinion in this regard. I believe these problems need to be solved. And I think they shall be solved and should be solved soon, as soon as possible. Thank you.
I'll allow one question, but then I do want to let the last speaker speak because we are running a little bit low on time, and then we'll have...
Shortly question.
Okay.
Brief question in German. Frank Engelmann from the Bar of Brandenburg, Germany. Your experience of a legal clinic in Samara region. What if a person comes to you and asks for legal assistance and say your service is checking him whether this legal assistance may be provided for free. How do you react if later, during the litigation, you discover that he actually did not have the right for this assistance, or vice versa, if you decline his claim, but later at litigation it is discovered that he did have the right for this free aid? That was my first question. Here comes the second question. What if the person has some problems with the authorities of Samara region and wants to get some money from Samara region authorities, and thus he's asking that a legal service to provide him legal assistance in his struggle against the authority of Samara region. How will the lawyers of that service react? Will they provide assistance acting against their own employer, or how?
Thank you for the question. It's a very interesting one. I will start answering in an orderly way. First, I'll answer the first question. The project I've told you about is not active at the moment. It's not operating. But let me tell you some history on how we used to solve such situations. First of all, of course, the center and the bodies that provided subsidized legal aid were subject to federal legislation. So we did everything according to legislation. Poor people, invalids of the first and second grade veterans, etc. I know that on the territory of Samara region there were cases when experts saw that the person is formally not eligible regarding the criteria, but they still provided it. Perhaps this may be considered pro bono. They just provided it on their decision with their own efforts. The project is not operating, but the continuation of that project is another very interesting project organized by the Bar Association of Samara region. On the initiative of that bar, there was formed a coordination center for providing of subsidized legal aid. It has a slightly different system. Yes, they do, of course, provide aid to the categories that are eligible according to the law, and they are provided free legal aid. But if the person is not eligible, he is offered paid legal services. As for your second question, it's difficult. I don't know how it was solved and whether there were similar cases. I believe the experts of those centers and the bodies that provided legal aid should provide legal assistance, irrespective of against whom this claim is. It may be against the interest of Samara region or against the interests of the Russian Federation. It's of no importance. That's regarding the question on the standards of the lawyer's activities and ethics. It's your client, and then you should provide assistance irrespective. But of course, it's a dual situation. I believe somebody will pay attention to that, because I believe it's not quite correct.
I said we'd go straight to the last speaker. Let me let Elena Dobrovikova, who's the director of clinical programs at St. Petersburg State University, add to that answer.
Thank you, Glenn. I'm the director of the legal clinic of St. Petersburg State University. Glenn, let me give you a suggestion. Several last questions are all about professional ethics in the field of legislation in general and free legal aid. Our panel about free legal aid
There's a lot of truth in these words. Maybe all of the truth is there. All the essence of legal values and ideals shows when free legal aid is provided. At present, those clinics should be created. It's really a must in response of clinical courses. Such standards should be formed in legal higher educational establishments, and they are being created. But there's a problem that Matthias mentioned. Not everybody understands pro bono correctly. Some call pro bono any free legal aid, and quite often clinics they call any obligation of students to provide free legal aid. Clinic is the issue of training, and we have a system of correct interviewing of the client to analyze his problem efficiently. And we do not separate the client and his problem. He's part of the problem, same as the legal facts mentioned in the law. And the law is also part of the system. Glenn, let us, at the next forum, discuss the mutual trust of lawyer and client. We keep talking, how can we obtain the client's trust to look respectable in his eyes. But now let's think of the other thing. We mention more and more frequently, how can we trust clients? Thank you very much for giving me the floor. I wish you fruitful work.
Okay, I am going to now go to our final speaker. I apologize for some improvisation in the ordering of the speakers, but perhaps in a way it's fitting that we end with our speaker from the Netherlands, as we've heard directly and indirectly to a certain extent today. The Netherlands is a model jurisdiction in terms of legal aid, and so we're very glad to have Herman Schildperoot, who is head of staff of Raad voor Rechtsbijstand from the Netherlands, who's going to give us some background on the situation in the Netherlands for legal aid and to a certain extent pro bono.
Dear listeners, I can understand that you're a bit tired now at the end of this session, but I hope I can still make some interesting remarks about how the state legal aid is organized in the Netherlands. Let me tell you first something about the main providers of legal assistance in the Netherlands. Of course, the biggest part of legal assistance is provided by the members of the Dutch Bar Association. Half of them is registered to work for the Legal Aid Board. Then there are the mediators, becoming bigger and bigger mediation in the Netherlands. Last year, the Legal Aid Board subsidized about 8,000 mediation cases, which is about 2% of the total of the cases we finance, but mediation is growing in the Netherlands, stimulated by the courts. Then there are the legal aid insurance companies. They're big players. They entered the country from Germany. DAS and ARAG are well-known players in the legal insurance market. Then, of course, we have the unions, which assist laborers in labor cases, and there's the consumer organizations. So, if you think about legal aid, there are a lot of different providers. If you take into account the turnovers of these different brands, then you will see that the biggest turnover is from the members of the Bar Association, 4 billion euros in 2011. The legal aid insurance companies have a turnover from 0.8 billion euros. And then there's the subsidized legal aid, the budget of the Legal Aid Board for which I work. We had a budget of 465 million euros. This is only 10% of what's going on in the market. I can't give you figures on pro bono in Holland, because pro bono is very small. Pro bono work is only done by the very big law firms, the very big commercial law firms. It's small due to the fact that we have good provisions for legal aid in the Netherlands. Reasons why the bigger companies do pro bono work is that they feel it as a kind of social responsibility. They do it to enhance their reputation, and they only pick out very principal cases, for example, cases for the Supreme Court to handle. Of course, they can't provide a solution to all these poor citizens that need legal aid, and you can't imagine people who are homeless entering the glossy firms, the glossy big law firms. These law firms don't have the knowledge and the skills to provide aid to the poor, in my opinion. In Holland, we have good provisions for subsidized legal aid. In fact, subsidized legal aid is guaranteed by our constitution. And we're dealing now with the second Legal Aid Act, which dates from 1994. The first one was from 1957. We had a big change in the system in 1994. And in that year, the legal aid boards were established in Holland. Let me tell you something about the system characteristics of Dutch legal aid system. The Dutch Legal Aid Board is set up as an independent administrative body that is accountable to the Ministry of Safety and Justice. Our board has at a maximum 3 members, and they are appointed by the Minister of Safety and Justice. Legal aid is provided in a mixed model with public providers, they're called the legal service counters, and private lawyers and mediators who register at the Legal Aid Board. Not all lawyers register, but about 50% of the lawyers is registered to provide subsidized legal aid. Aid is granted for all kinds of legal cases, no matter what. Civil cases, criminal cases, administrative cases against governmental bodies, and asylum cases. And we provide all kinds of services, advice, assistance, litigation, mediation. Legal aid is provided in different manners. Via the internet. We developed a conflict resolution guide. We did this together with legal professionals, citizens, and the universities in the country. We developed an online negotiation tool. You can check on the internet whether you have a legal problem or not, whether you should go to a legal service counter or not. You find some ways of assistance on the internet, for example, simple letters in consumer cases to complain about a bad product. When this is not enough to support you, you can go through the first line, in which we subsidize the legal service counters. They are public providers for free legal aid. You don't pay a contribution there because we want to encourage people to go to these service counters for first advice. In the second line, for more complicated cases, and cases in which you really need a lawyer to bring your case to the courts, we work with the lawyers and mediators. In the second line, people always pay an own contribution, and we check, of course, their income and assets. In addition to this, we arrange duty solicitor schemes for custody cases. When people are picked up from the streets, suspects, alien psychiatric patients, we send a lawyer within 24 hours. And in criminal cases, even in 2 hours before interrogation, the lawyer has to be there. In principle, people have free choice of a lawyer or a mediator. At least he should be registered at the Legal Aid Board in advance. Let me tell you some more about the legal service counters. We have 30 legal service counters all over the country. Holland is a small country, so you will find them in 1 hour traveling from the place you live. These counters are meant as a low threshold for access to justice. The exposure of the counters is that they are meant for low-income people. So really rich people won't go there for free advice, I think. They are easy accessible. You can send a mail with your questions. You can call to the call center. There's one telephone number for the whole country. Or you can visit the counters. The task of these legal service counters is to clarify legal issues, to provide information, to give first advice. For a case, they have at a maximum 1.5 hours, but so much time is not often needed. In difficult cases, they will refer you to a lawyer or a mediator. These counters have an important screening function in our system. That's why we encourage people to go there, because the help of the counters is quite is not very costly. You know, for an advice, we don't pay the counters much money, not as much as we do to a lawyer. So this is why we encourage people to go there. Also, a good advice in an initial stage of the case will enable people to make a choice whether they will make further proceedings or not. They have an idea about their situation and about the costs they will have when they take further steps. We encourage people to go to the legal service councils, as I told. When they've gone there and go to a lawyer afterwards, they get a reduction in the contribution they have to pay to the lawyer or the mediator. Now the secondary line. In the secondary line, we work with lawyers and mediators. The secondary line is meant for advice in complex cases and for litigation. In case of a low-income client, a registered lawyer or mediator can apply for subsidized legal aid at the Legal Aid Board. He fills in the form which he can send to us via internet. Then we do, as we receive this form, means test, significance test and a merits test before granting legal aid. The means test is done electronically in connection with the Dutch tax administration. We think the tax administration is best in control over people's income and assets, so they are better in controlling the things than we can. So this is why we made an electronic connection, and we get information about the income and the assets from the tax office. And we take into account income and assets of 2 years ago. If people say that their income and assets were lost, they have to prove that their income is within in the standards at the actual time. Then the payment system. The payment system for lawyers and mediators is based on fixed fees. So on average we pay a fee of 800 euros to a lawyer for a case. And from this amount of money, the own contribution of the client will be deducted. The client has to pay his own contribution to the lawyer. We deduct it from the payment we do to the lawyer. Only for complicated cases, lawyers can provide extra hours, and then they have to prove that the case is really complicated. In this dia, you see some figures about the development of legal aid in the Netherlands. As we started with the Legal Aid Board in 1994, we handled about 200,000 civil cases. Now it's more than 256,000. So it's a growth of 27% in these cases. In criminal cases, there is a bigger increase. We started with 73,000 cases. Nowadays, it's almost 160,000 cases, an increase of more than 200%. In asylum cases, you see a decrease. We started with 30,000 cases in 1994, and now it's about 25,000 cases. Then some figures about the duty solicitor schemes. You see a growth of the cases over there from 65,000 in 1994 up to 128,000 right now. This is due to the Subsidized case. Many of you will know. The suspect has a right on legal advice before interrogation now, so this will increase the number of cases in the duty solicitor schemes. Then last but not least, there is the client context of the legal service counters. They had more than 800,000 client contacts in the last year. So you see these numbers are increasing. It's one of the problems of subsidized legal aid, I think. This dia you see some figures about the expenditure of the Dutch government on legal aid. Our population was growing a bit from 1994 until 2011, 1 million inhabitants more. But the spending of the government pro capita increased from 12 euros till about 28 euros. This has something to do with the increasing of the fees of the lawyers, because lawyers nowadays are better paid than they were in 1994. But the government spends much more money on legal aid in these days than it did in 1994, and this is something to be worried about. Is the Dutch system successful? I say yes from the client's points of view. In our country, 6% of the people is eligible for legal aid. And our system is really serving the poor. More than 80% of the people who are served in our system have minimum incomes. And legal aid is provided mainly in cases that can be handled via pro bono or insurance companies, like family law cases, criminal law cases, alien law cases, social security cases. You won't find an insurance company that will cover these cases for you. So from the client's perspective, our system is quite successful. But there is also another side. Like I said, the costs have increased during the years, and some measurements were taken to get more control over the budget, like raising the own contributions of the clients and cutting down the fees of lawyers. But still, these measures were not enough to really control the budget. So we have to think about new ways to keep the budget stable, or to get a decrease of the amount of money that is spent on legal aid. And I think, and I and my colleagues in the Legal Aid Board thinks that most challenging is to reduce the dependency on legal aid and all conflict resolution methods. Preventing problems is better than curing them, we think. And a lot of problems are caused by the fact that laws are very complicated. Do laws have to be as complicated as they are? This is a question we should ask ourselves. If we implement new laws, are the rules clear enough, or will there be disputes about these rules? Rules have to be less complicated, we think. An example are the alimony rules in the Dutch system, which are at the moment very complicated. So we are asking for a more easy way to calculate the amount of alimony people have to pay for their ex-wife and for their children. And there is taken an initiative from our parliament to make the rules for alimony easier than they are. Another thing is the divorce situation in Holland. Even if you agree on divorce, you need a lawyer to go to the court to divorce. And we think that an administrative divorce could be a solution, could reduce the number of cases in which people need a lawyer. In fact, if you agree on the separation and on the conditions, why should you need a lawyer? My wife and me, we are both lawyers, but why do we need a lawyer if we want to divorce? Luckily, we don't want to divorce, but why should we need a lawyer to divorce? I don't know. Yes.
You only have to bow 3 times to Mecca.
Also, there is a role for the government bodies. A lot of legal proceedings are against government bodies, and we think government bodies have to act different from what they do now. They need to invest in more personal contact with the citizens instead of writing complicated letters that even I can't read. They should use more the telephone in complicated cases, in initial stages, to get information from the citizens or to inform the citizens about the decision they can expect. And also the use of mediation in complaint procedures against government bodies could be of help to reduce the enormous numbers of cases against government bodies. And then there is the criminal area. In the criminal area we have a new development in Holland, which is called the as soon as possible method. This is a method which deals with common crimes, not the big crime, but the normal common crimes that often occur. Until a few years ago, all these cases were brought to the courts, and a lot of people asked the legal aid board to provide them a lawyer to assist them before the court. And you can ask questions: is this necessary? Is it necessary to bring common crime, even if they are simple cases? Is it necessary to bring these cases to the court? So now new instruments are given to public prosecutors to impose light punitive measures, and this can reduce the amount of cases in the criminal area we subsidize. So these are alternatives for the enormous amount of money that is spent on legal aid. Other alternatives are the need to empower the citizens. Further development of our conflict resolution guide. as I told you, can check whether your problem is a legal problem or not. You can find letters for simple cases on the computer right now on the internet. But we also want to arrange an easy access to consumer complaint commissions via the internet, so that people who are on our conflict resolution guide can immediately send their case to one of the complaint commissions that we have for consumer cases. We are now also realizing internet models for divorce plans, parenthood plans, and we have introduced an alimony calculator on the internet. These are means to assist people who agree upon divorce and also have an idea how to handle their case on their own. It's a do-it-yourself divorce. In our opinion, this is possible. In fact, as I told you, we have developed all these models with the assistance of legal experts and universities. And there is not much criticism on these models from the Dutch bar. So I think it can work. It can work, and it can reduce our expenditure on divorce cases. Right now we are starting with a combination of the online self-help and online coaching. So if you have a problem handling your divorce case together, you can ask questions. You can immediately refer questions to experts so that you can proceed in your divorce plan. Then at last, legal proceedings must become easier in our opinion. Access to justice is complicated, and at this moment you still need a lawyer to present your case to the court. But the Dutch courts will start with the development of digital court proceedings so that people are able to bring their case to the court by themselves via internet. Also, this will reduce, I think, the number of cases in which people need a lawyer to bring their case to the court. And finally, judges will lay more emphasis on assisting parties to reach resolutions for the problem when they are in the court. A mediation way of handling problems instead of procedures with only documents. So I think this is a perspective, a modern perspective on problem resolution, which can be an alternative for legal aid system. Of course, in many cases, legal aid still will be needed, but I think that now, while laws and procedures are so complicated, people are really dependent on lawyers, which shouldn't be the case. So we hope in seeking alternatives that we will be able to sustain the good system for legal aid we have in our country. That was my presentation about the Dutch system.
Okay, we don't have that much time left, but we do have some time. So let's start with some questions here in the... No, I was you. You could start.
I would like to ask you, because maybe, sorry if I have not noticed, but what about choice of lawyers? Do you define people who use legal aid?
I'm sorry.
Does it work?
Yes.
Yes. Could you tell us how the lawyers are chosen by the clients? Do the clients have choice of lawyers?
Free choice of a lawyer.
Free, obviously.
Yes. In Holland we have about 16,000 lawyers, and 7,000 of these lawyers registered at the Legal Aid Board to do cases for us. It's it's almost half of the bar, but the other half is mainly very big law firms who only do cases for big companies and governmental bodies. So lawyers who provide legal aid to private people mostly have registered to do cases for the Legal Aid Board.
No, but my question is, I am the poor citizen and would like to and need to get the legal assistance, and I qualify myself to legal aid. Then, do I have the chance to make a free choice of lawyers?
You can choose one of these 7,000 lawyers.
Yes.
So there's a big choice.
Okay, thank you.
Additional questions? Matthias.
Thank you for your presentation. It was very interesting to me how your system works, and I think it's good that I saw it on your first slide, I think, something that is quite important in the German system as well, that we have not touched upon yet, and that is legal insurance. I know that legal insurance exists only in very few countries. The way it works in Germany is that you pay like a monthly rate or yearly insurance premium, and then when certain cases come up, the insurance pays for your lawyer, and the lawyers are not compensated based on an hourly fee, but on statutory fees, which relates to the amount at stake. And that's, I think, lawyers, that's my observation, I have no statistics, generate a good part of their income from these legal insurance companies, and they provide some security to the client, and at the same time, I don't know whether we have some Russian business people here too. I think the person who came up with this idea in Germany is a billionaire now.
Typical German way of loving insurances against everything.
How much? It's 10%?
Yes, 10%.
Okay. Yes.
It's a bit of a joke, but the only problem with these insurances is that they are very good at explaining why it's not under the insurance.
That's why I was telling that it's not a real alternative for subsidized legal aid, because they won't help you with your divorce case. They don't help you with a criminal case. They don't help you with a social benefit case. If they would cover all these problems, the premium would rise to a level that is not attractive anymore in the market. So it's always good to have an insurance. I have also legal aid in insurance, but it won't cover me for every problem.
One or two final questions or comments from the floor? Yes.
Good day. I have a question about pro bono. We were talking about free subsidized aid and about the standards of legal services, but pro bono, what are the limits of responsibility of the lawyer in pro bono process, and what is it for you? Is it charity or socially oriented business? Thank you for an interesting but very difficult question. I'll begin from the end, and I'll answer that for us pro bono is, first of all, charity. Yes, of course, to a certain extent, pro bono influences our business as well. one shouldn't lie. Indirectly, it does influence business, and the experts doing the pro bono and analyzing the pro bono, they state that it's a way to improve your business. It's not a secret, it's a fact that in certain cases the presence of pro bono practice in the activity of a legal company may improve your business. It may help you win certain legal tender, for example, where one of the criteria is the presence of pro bono practice if the client arranges the tender in such a way. Many ratings of legal firms include the item pro bono. Thus, indirectly, it does influence business. But if you make a decision for yourself, what is it, charity or socially oriented business, I think the answer is yours. It's your attitude to the issue. As for the consequences, it's the secondary issue. The main thing is your attitude. So our primary attitude is that it's charity. Sorry, let me give a small comment to the last presentation. I have a question whether the activity of barristers business or a different social phenomena. It's a matter of discussion. It's a disputable issue. So I believe the question wasn't formulated in quite a correct way, or the answer was pre-set, pre-offered. Of course, providing of free legal aid is charity to a certain extent. To a certain extent. I will tell you more. Sometimes, for certain cases, I do not ask the Bar Association with a request to pay for the legal services I've provided. It happens for several different reasons. Sometimes, perhaps, for the reason that the person I protected will not pay to the government for what I've provided for him. Here is my question to continue our discussion. What's the relation between the Bar Association of Samara region and the Government Legal Bureau of Samara region regarding providing of free legal aid? What kind of relations they have? Is it friendship or war or indifference or something else? I'm sure there is a certain relationship. It can't be nothing, but I believe there must be competition. Thank you for the question. I'll try to answer it in as much detail as possible. Though I'm the member of the Bar Association of Samara region, I represent advocacy. I cannot speak on behalf of the whole association, and I can't speak on behalf of the Government Bureau as well. Can't tell exactly about the relationship, but I believe the relations were reasonable, rational. Both bodies were the participants of that agreement I mentioned earlier, the agreement on coordination of the activities in the field of subsidized legal aid. You could regard it in a wider way. We do have a discussion in Russia. The discussion is on whether certain separate bodies are necessary in Russia for providing of free legal aid. Some believe that government legal bureaus shouldn't exist, that these are artificial bodies, artificial tools that are not efficient, in fact. I know the opinions about the legal clinics. The opinion is that the clinic should not participate in providing of free legal aid because it's students that do that, and they are sometimes experimenting on clients. They say whether this is correct. Is that correct? My opinion, I believe, is that the more bodies provide free legal aid, the better. We really need, there's a need in the society for free legal aid. We have shortages of experts and bodies who would provide it. So why should we artificially limit the number of bodies or the list of bodies that provide these services? The issue is the quality control, to make each of the bodies work well. That's a different issue. All the rest is very disputable, and I believe the clients, the people that need this aid, shall decide who to apply for aid. Bureau, barristers, private center, or whatever.
I think I'd like to say just one word, which is that in terms of the issue of quality, in my mind, the issue, first of all, is to assure that the same standard pertains to legal aid or pro bono legal services as obtains to paid legal services. So the mechanism that exists, whether it, for instance, is through the mechanism of the bar associations and disciplinary review, which, for instance, in my jurisdiction in New York, is then maintained by the Court of Appeals as the highest court of the state. This mechanism has to pertain also even if the services are rendered on a non-paying basis. Similarly, in a law firm which is providing pro bono legal services, one has to assure that the same standards of quality, the same standards of also ethical conduct of lawyers are maintained irrespective of the fact that these services are being provided on a pro bono basis. So to me, this is the key. I think that the standards have to be for the profession as a whole, and those same standards have to apply in pro bono or legal aid. It's not that we need to have a separate standard for legal aid, for instance. It should be the same standard as the standard for paid legal services. At any rate, we're now over our time limit. The conference is ended.
Sorry, let me continue answering the question. I didn't finish answering the question that I was asked, and it's a very interesting question. It was about the responsibility of lawyers for low-quality legal assistance. What's the responsibility? As I've mentioned before, in fact, between the consumer and the lawyer, there's an agreement. And this agreement provides certain legal relations. So this is civil legal responsibility provided by the civil code, like you can claim losses. I don't think there's a problem, because the basis for that is the civil legal relations. And now, when we talked about charity or business, is it a present or a service? If it's a present, how can you claim for bad quality? That depends on your attitude. Maybe a usual deal, contract but with no payment. Contract on providing of services but with no payment. That depends. There's no uniform answer to this question. It depends on the will of the parties when they enter these relations. I'd like Matthias to answer this question. Say, you provide services for NGOs or some other lawyer decided to provide the charity, but quality was bad and you lost the case, and the party believes the quality of legal service was low. Can the receiver of pro bono services claim a lawyer and require for the material
Again, I'll
reimbursement
take
of
a stab
losses?
at answering this. It seems to me that okay, sure.
Yes.
I'll give a slightly longer answer, and that is, again, that the same standards of liability for paid services and for unpaid services should exist. For instance, in the U.S., for an attorney or a professional to have material liability, the standard is fairly high. In other words, it can't be simple negligence, it has to be a level of gross negligence. But that same standard, whatever the standard happens to be, negligence or gross negligence, has to apply irrespective of whether the services are provided on a non-paying or paying basis. Okay, and I do think now that we will come to an end. I would like to thank you for being the diehards of this conference, of staying to the bitter end. I do believe it's a very important subject, and I appreciate your participation very much. Thank you. Thank you again to the organizers, and especially thank you to our panel.
And thank you very much to our moderator. You have done a fantastic job. And from the panelists, I think a very warm thank to all the interpreters. Thank you so much.
Thank you. And all of the technical people and staff people who have been helping.